there are a litany of threats that confront us on both the immediate time frame and the long-term time horizon, and I think the opportunities to push back are several. So if I have an overarching point here, it is just to contextualize the opportunities within a range, basically to develop, rather than a narrow framework, a broad menu that includes a multifaceted agenda. So just to pick out a few things that have come from Professor Erlander's comments. At the moment, there are at least 4 different sets of amendments in the Constitution that have been, for all intents and purposes, eviscerated, each one of which creates opportunities at both the local and the federal level for advocates and organizers who are willing to frame creative campaigns. So with respect to the First Amendment, there's at least 2. There's the rendering speech non-criminal in the context of the material support issues that Professor Erlander and Steve were talking about. There's the issue with respect, and this isn't actually implicated so much in these cases, but is in more of the popular culture today, defending religious pluralism in the face of attacks on the Establishment Clause and the Free Exercise Clause. It's a little bit unique in that that's sort of a remedy vis-a-vis private sector bigotry versus public sector stuff, right? Prosecutions, which I think are what we're particularly talking about here today. The Fourth Amendment has been, Steve touched on it a bit, but the practice of surveillance, even unhinged from any individualized suspicion at all, which has been admitted by the FBI before the Senate Judiciary Committee in July, interestingly enough, in a note sent to the committee after the cameras were off. And just to unpack that, in a hearing in which the dominant storyline was that FBI agents don't know the limits of their powers and so we're systematically abusing them, and in the hearing, the director essentially proved that neither he nor knows the limits of the Bureau's power. And in the context of the raids, the Friday before this past one, it's interesting to know, 4 days before those raids, the Inspector General of the Justice Department released a report documenting political surveillance by the FBI in multiple cases. And the IG's report was relatively restrained. He essentially chalked it up to incompetence rather than intentionality. While the FBI is blundering about they happen to violate people's rights, and so maybe that gives Congress some comfort, but it shouldn't give us any. And just to go back to what that means in practice with respect to the jurisprudence, the Fourth Amendment's always required individualized suspicion before even being searched. Right? The idea that you can be monitored and tracked for years at a time and a body of evidence that will then be held largely in secret used against you is in profound contravention to a very fundamental freedom. The Fourth Amendment was not ancillary, right? When the Constitution was drafted, it is very much a central bedrock on which the rest is built. The Sixth Amendment, the right to counsel and the access to confront evidence being used against you, I see that as particularly the locus of the opportunities to push back on these prosecutions, right? The opportunities to know the violations in them. With respect to core, again, civil rights, the Sixth Amendment has long required the right of access to exculpatory evidence. And the idea that multiple departments among federal agencies in their internal watchdogs have issued a recommendation to Congress that they revisit these prosecutions to assess whether or not those constitutional requirements were followed is, quite frankly, a huge opportunity to do a lot of good work, I think, to really dramatically shift some excesses that have existentially altered the course of a lot of people's lives, many of whose names you see here before us. And then the last, which I want to particularly invite attention, is the 14th Amendment and the requirement for race neutrality. Religion is also a protected class under the 14th Amendment, and the idea that, and this is where I want to drill down a little bit, the idea that particular communities are vulnerable presents also an opportunity, because if a campaign is framed within the particular and specific context of prosecutions of Muslims, and I gather that the FBI raids and any potential indictments that come out of it may expand the pool to include some white progressive anti-war activists, and while I would certainly hope for no one to face the armed spearhead of the state, I recognize the opportunity in the community of interest expanding. Having said all that, there is a difference between a campaign that is framed around solidarity with Muslims and a campaign that is broad enough to be framed around the constitutional rights that Muslims share with everyone else, including Latino Americans, African Americans, who struggle with many of the exact same issues. 14th Amendment derogations, 4th Amendment derogations, 6th Amendment derogations, and potentially first. I mean, the ways in which speech is implicated for Muslims, I think, is very different than some of those other communities, right? And the particular implication of surveillance as an investigative tool applies, or at least has been applied differently. But just to drill down on this, it's the delayed the delayed notice searches authorized by the Patriot Act, what many of us call sneak and peek. The majority of those cases, they're used in drug investigations, right? So it's not the paradigmatic sort of fear that justifies the creation of these powers that limits how they're subsequently used. And for us as advocates to ignore that, to overlook that there are multiple communities that share interests in the rights defined in the abstract, in the 14th, 4th, and 6th Amendments, or the 5th for that matter. I mean, you could sort of go on, a lot of them apply, depending on how you construe them. But the point being that at both the local level and at the federal level, there are opportunities on each of these fronts. And I'm very eager to see the coalition engage in a broad menu. And I think that serves a bunch of different purposes. The first is that it plays offense versus defense, right? There is a phenomenon over the last generation of every vulnerable community fighting isolated fights against different three-letter federal agencies, and all of us, for lack of a better set of terms, getting our behinds kicked. And it makes sense because we're fighting different struggles, right? When mobilizations from grassroots sources win, it's because they cut across boundaries and they unify voices. And I think there are opportunities around that. Just to share a quick case study, there's a bill in Hartford, Connecticut, it's the state capital that Lieberman represents. And more important than the reforms, which I could drill down into, to me what is compelling is the coalition pushing it. So there's a state chapter of or affiliate, I should say, of the ACLU, state branch of the NAACP, state care chapter, a local drug policy group, a local immigrant rights group, two different student groups, and the local peace and justice coalition. And the reason that the reforms have attracted so broad a set of interests is precisely because they concretely offer enforceable rights to each of those communities. Right to the peace and justice community is we're going to take the local police out of the business of surveilling you on the basis of your First Amendment protected speech. To the African American community, it's okay, we're going to start tracking the demographics of people stopped, searched, arrested, and charged, so that there'll be some transparency into the extent of racial profiling. To Latinos, it's the same thing, and will block collaboration between our local police department and ICE. And to Muslims and everyone else, it's the restoration of the Fourth Amendment barrier against dragnet surveillance without individualized suspicion. And so these campaigns, and I guess to step into a different direction, but it's another distinction here, I think it's, as a lawyer, right, I am trained to focus on very discrete analytical distinctions. Our political culture is, to be perfectly frank, not sophisticated enough to do that. So when we engage these struggles, it is more important that we do it with a political awareness of the background principles than with a fetish around the legal distinctions between these different campaigns, right? The difference between a campaign framed on these First versus Fourth Amendment rights, or the 14th, is more legal than political. They are absolutely aligned, and it is in the alignment among movements to achieve each of these multiple objectives. That is where our opportunity lies as a coalition, I think, to build space.